morning, good noon, and good evening. Namaste to everyone whosoever has joined us for today's webinar, web event. I, along with my friend Mr. S.S. Ray, and on behalf of Nivara, a collective of Mediators Association of Supreme Court of India, welcome you all for this event, which is on a very important topic, putting mediation on a statutory footing, opportunities and challenges we have with this. So for this, we are really blessed and fortunate to have truly two eminent legal luminaries for this, Mr. Sriram Panchu, Senior Advocate and Senior Mediator. We welcome you, sir. Dr. Venkat Iyer, Barrister and Senior Mediator from Belfast. Sir, we welcome you on behalf of everyone here. Thanks for joining us. This topic is so relevant and important for us. Why? Because we have seen in last more than a decade, Government of India, Honorable Supreme Court, High Courts of our country, along with district courts, litigants, advocates, everybody has contributed towards making mediation as most appropriate dispute resolution mechanism by way of various initiatives, be it amendments in the legislation enactments, various judgments coming up. Even advocates have supported the cause of mediation. This all was to strengthen and motivate the mechanism of mediation. But we always felt that our country should have a separate independent legislation on mediation. So our government of India has started with its drive, wherein they have recently just floated as a pre-legislative process, consultative process, a draft mediation bill 2021 to invite everyone's views and concern and suggestions so that our country can witness a sustainable possible legislation, which is going to be an umbrella legislation on mediation, where we have an umbrella regulatory body also as Mediation Council of India, which is very important. So it's going to be really, for us in India, it's not less than an independence movement. I can say it's going to be an historic moment because every stakeholder will be free from the shackles of high litigation costs, time, unpredictable times we have, appellate structure, public scrutiny, and list is endless when it is attached to the traditional court system. So for us, this draft mediation bill, which will certainly bring a legislation, complete self-contained legislation, is ray of hope, which I can say is perfect because today my partner is SS Ray. So this draft mediation bill is not less than a ray of hope for each one of us. And this month is very good for us to deliberate on this topic, great topic, because India received its constitution in this month. That was 26th November 1950. So this is a very crucial, important month so that in times to come, under the drive of Government of India, we have an Atmanirbhar legislation on mediation, which is full of the features of Constitution of India. We can say it's going to be a constitution of mediation, having a complete spirit and feature of sovereign, socialist, secular, democratic republic made available to the people of India with full features of preamble as to equality, justice, liberty, fraternity, unity, and integrity. So this legislation, draft mediation bill, as of now, which is floated for the public opinion, for the stakeholders' opinion, right now has 37 sections, with divided into 4 parts, 7 schedules. So there are areas which certainly needs lot of deliberation and correction, which we feel there are positive sides also, but there are areas which need certain corrections, and that is why the stakeholders' advice and views have been invited by the government so that everybody can together fill in the lacunas whichever is which is there in the draft mediation bill. And today, before I invite Sriram Panchu sir for this very great moment and which is very significant for us, it's an opportunity for me, and rather I would say a challenge, a big challenge for me to briefly introduce Sriram Panchu sir. The topic is opportunity and challenge, but for me to introduce him briefly is also a challenge. But let me just try before I invite him and for his views, because sir has been part of the panel which was constituted by Honorable Supreme Court in January 20, I think it was in 2021, wherein they want 2020, wherein they wanted the panel to give the draft mediation legislation to the government. So, sir was part of that panel. So, to the audience, let me just briefly introduce Sir, Mr. Sriram Panchu, sir, a senior advocate and internationally recognized mediator who has been instrumental in bringing mediation into the India's dispute resolution system, a certified mediator on the panel of Singapore International Mediation Center, a founder of Concord Mediation, which offers services in mediation and MEDA. Sir is president of Mediators of India Association, a national association of Indian mediators, and a director on the board of the International Mediation Institute, IMI. He has set up India's first court annex mediation center in Madras High Court in the year 2005. Mr. Panchu has mediated large number of complex and high value disputes nationally and internationally across the range of commercial, corporate, contractual disputes in different parts. He was appointed by the Honorable Supreme Court of India to mediate a border dispute between two states, another public dispute involving Parsi community in Bombay, and recently an Ayodhya dispute. Sir has authored two books on mediation. One is Settle for More, The Why and How and When of Mediation, which has introduced the subject of mediation to the Indian audience. And Mediation Practice and Law, The Path to Successful Dispute Resolution. Sir has also authored Indian chapter of Getting the Deal Through. The Supreme Court has referred to him as distinguished mediator, eminent trainer, and one of the foremost mediators of our country. And to us, we fondly call him as father of mediation in India. Mr. Panchu was part of the panel, which I've informed panel of the panel and committee to draft mediation legislation. So I please just join me and to welcome and invite Mr. Panchu to share his views on the draft mediation bill and whether it meets out his expectations with which he guided the government with draft mediation legislation, which are the areas which needs corrections, and we can go further to have really a rational legislation which India can witness soon. Thank you, sir, and we invite you. Mr. Sriram Panchu, sir. We welcome you, sir.
So, do I begin now? You know, in a way, having a legislation for mediation seems like a contrary thing, because mediation is so dynamic, so organic, so free of the clutter of rules and precedents. But having said that, let me make the point that I think this act will take mediation a long way. All these years, I mean, the springboard for mediation has been the court annex system. We introduced mediation through the courts because we thought basically that, it's only through there will it gain acceptance. That the users and the public must see it as something sanctioned by the courts, blessed by the courts, done by the courts. And I think we were right in that approach, because once it got into it became, part of the court's business to have mediation centers, train lawyers, refer cases. I think that approach was really a good springboard. But all along we knew that a mediation has to be really sustainable. if you have to get, high-level expertise, commitment, uh, for people to make it a career, to give it that kind of focus, then you have to move to private mediation, to professional mediation, where it's as much a career as lawyering is. And I think this bill gives us that opportunity. Our first stages of drafting the bill, we had provisions, in fact, one section for court annexed mediation, one part. That's got removed and left to the courts to do as they wish. So really the focus of this bill is the ability to drive mediation, to take it on to the full-fledged professional platform. So I would say that's the first important thing about the bill. I'm sure everybody has read the bill. So you would have noticed that the thrust is through mediation institutes, service providers, and mediators. So the bill provides for the institutes which can train mediators, service providers who can administer the service, who have mediators in their roles, who will have rules and who can administer the service, and mediators who could be part of the service providers panel, or who can be ad hoc mediators chosen by the parties because they want this particular person to be the mediator. So that is a structure, and it's a structure which suits professional mediation. I think with the least amount of kind of control or overseeing or micromanagement. We don't have too much of that in this bill. We have the creation of these institutions. Plus, we have the the confidentiality provisions were laid out, the protections, role of mediator, conduct of mediation, the commencement, the closing, limitation, the manner of appointment, the disclosure of interest, the starting, the termination. So all that is there on the map. I think the key driver of this bill is the pre-institution mediation clause. And we are probably going to be one of the handful of countries in the world who insist that before you go to litigation, you try mediation. Not an insistence on resolving through mediation, not an insistence on that you must participate in any required number of sessions, etc. But all that this bill asks for is that before you go to court, you have one substantive sitting with the mediator. You get a mediator from a service provider, or you choose your mediator, have a substantive sitting. And if after that you feel you don't want to try mediation, there is no compulsion. So the ask is very limited. The requirement is very limited. But it is that requirement which I think is going to take mediation a long way, because in a mediation, you open out the eyes of the disputants as to what is possible for them in mediation and what lies ahead for them in litigation. It's all up to the mediator at that point. So the pre-institution really is, I think, going to be the big driver. And here I'm going to raise a concern. do we have enough mediators in this country to handle the demands of the litigating public who are told that they have to go to pre-mediation before they can access the court? That's a question which worries me. And to share it with you, when we were drafting this, we thought initially we should bring in pre-litigation mediation in stages. First do commercial, personal, consumer, property, then move on to other aspects. But the drafting authorities at the official level seem to have thought it fit that we will subject all cases to pre-mediation. So this is something that as mediation organizations, we should be careful about this. We should worry about it, and we should watch. I mean, supply has to meet demand. We cannot leave people stranded for lack of mediators. So this is a concern which I want to express, and I think we should do also our own audits. How many cases are being filed? How many mediators do we have? And so we have to kind of burn the candle and work for long hours to take care of the number of cases that we should. Okay. That is one concern. The other concern I have is the composition of the council. I'm sorry, Push. How many minutes do I have really? I think I finished about 8 to 9 minutes.
20 to 25 minutes.
The other concern is the composition of the council. And on the council, we have it headed by a judge, the Supreme Court, or Chief Justice, the High Court, or a judge of the High Court. And there are two other full-time members appointed by government. My concern is all these appointments are government appointments. And I think we should work out some way that the judiciary plays a role in these appointments, because mediation is part of the dispute resolution package. We are intimately tied into the courts, and I think we should have a way of the judiciary being there in the appointment system. Plus, I think we should have provision for mediators to be on the council. I don't think it is sufficient that somebody who's knowledgeable about dispute resolution is a member, and the third member is somebody from the academic world. I think you should have a representation for practicing mediators, because they, above everybody else, will know the problems, the pitfalls, and the solutions. So I think the composition of the council requires a serious look. The Act provides for a list of exclusions in Schedule 2. And I think that is too widely cast. You see, we have this practice of looking at other enactments and grafting from that. So what we have here in Schedule 2, there is an exclusion for all cases where there's an issue of fraud or coercion, whatever. Now, we know in practice that when somebody files a case against another person, they throw in everything that they can think of. So there will be fraud, there will be misrepresentation, there will be this, there will be coercion, all of that. Finally, when it comes down to a mediating table, they're not talking about that, they're talking about how to settle. So to exclude cases because there is a mention of fraud or coercion is I think not a good way to go, and we are trying to explain that to to the drafting authority. There is also an exclusion for cases against minors and people with disabilities. Now, I have a bit of a concern here. What if it is in the interest of the minor to have something settled? And if you're going to wait till the minor reaches the age of 18, you can't mediate. So I think it's far better that to say that where it involves a minor or a person with a disability, etc., you need the sanction of the court to attempt mediation as well as to certify the result. I think that would be a good way to go about it. For example, I mean, even if you take up, let's say, a joint family, there are 8 to 10 sharers, and they have a property, and it is in everybody's interest to sell that property. But if you cannot mediate because one sharer is a minor, then it causes prejudice to everybody. So I think the best thing is to say, yeah, a court can say go ahead, and a court must look at the result. Some other areas are, again, I don't see why you cannot mediate a case which is where a patent is involved or a copyright is involved. Very often these cases settle quite well. And the mediator is not going into the validity of the patent or the copyright. But you will have settlements where one party will give up its claim based on whatever consideration or appointment. These are quite common in mediation. Similarly, telecom. Telecom disputes do quite well in mediation between service providers, users, intermediaries. So I think the list of exclusions is quite unnecessarily large. A fourth issue I have relates to the Singapore Convention. Now, in the bill, there is a part for domestic mediation. Where mediation is being held in India, the parties are from India. But in that, they have put in international mediation. Now, the inclusion of international mediation in a part dealing with domestic mediation creates a problem. And the problem is this. Under this statute, under Section 28, a mediation settlement will have the force of a judgment, order, or decree. But when you go to the Singapore Convention excludes cases where something has the effect of a judgment, order, or decree. So what then happens? I mean, if you say, if you're mediating in India, and if it is an international mediation, you will have the force of a judgment, order, or decree. Probably well intentioned. But the result will be that people will not want to be excluded from the Singapore Convention. Because that convention allows you to travel worldwide and seek for the best place where you can go to the assets of the person not in compliance. What will happen is, in those cases, disputants will say, well, we will not mediate in India. So that we get out of this domestic mediation umbrella. And you will have them going to Singapore or wherever. I don't think, this was really, fully understood. But if we leave things as they are, that is what is going to happen. And we all know, business wants the benefit of the Singapore Convention. The foreign companies will want it, Indian companies will want it. I mean, for them, that's their best bet of getting over this difficult dispute resolution clause, which, as we know, always comes up when agreements are being drafted. And we thought that, it is simple for parties to say, if we have a disagreement before going to arbitration, we'll go to mediation and we'll be covered by the Singapore Convention. That is, I think, in danger with this. So that's the fourth, area of my concern. So I think we are making, a lot of progress in this Mediation Act. We're making a lot of progress, but we're also running, a little too close to danger areas. And I hope that, in the few days to come, that we can convince the authorities that, there needs to be rectification, because I don't think there's an issue of principle over here. I don't think there's any basic issue of which cause us difficulty. I think it's basically a question of a better understanding. So hopefully, all together, I think if we make the representations, I'm sure government will listen. I've discovered one thing in this process of trying to assist in drafting this bill. And what I've discovered is that it's far easier to litigate and denounce and strike down a bill than to sit and draft one. I mean, I have my admiration for people who do this on a daily basis. So I used to use an old rhyme, in a lighter moment, there's an old rhyme that says, I'm the parliamentary draftsman, I make the country's laws, and of half the country's litigation, I'm undoubtedly the cause. I used to use that quite often, but I have a lot of sympathies now for people who have to sit down and draft acts carefully. So yes, I think we should work on sorting this out. Let me say something else. We have to be cognizant of the fact that out there we will have members of the bar who feel that they are losing out. And I think we have to take special efforts in that connection. To show that lawyers are as much part of the mediation world as anybody else. That it is lawyers who become mediators. That it is lawyers who accompany parties to mediation. That lawyers are entitled to their professional fees for representing parties. And I think we must get rid of that notion of champertus conduct, where under the Contract Act you cannot have a fee based on the result of a case. That was put in to discourage litigation. You can't apply that same thinking to mediation, because in a mediation here you're doing the reverse. You're finishing off litigation in a good way. And therefore, I think this concept of I can be paid only per sitting should not be the only one. I think lawyers should be entitled to a proper fee, a mediation fee, to be agreed on between lawyer and client. So I think we have to take a look at that fee system also and open that up. So let's be cognizant of all that. But at root, this is a fantastic opportunity. This is a fantastic opportunity for the for mediators to prove themselves, and indeed, I think uh, this working well is what is going to salvage India's legal system. There is just no way we can handle the bulk of work coming into to our courts. The more judges you appoint, the more appellate judges you'll have to appoint. But this is the only way of reducing the burden of the courts. And it's not just me. I mean, every senior judge is saying that. So there is a great deal which hangs on us as mediators, which depends on this act working out well. And with this, I'll stop now, and I'm looking forward to the pleasure of listening to my friend Venkat Iyer.
Thank you so much, sir. Thank you so much for your views on the bill. Certainly, sir, first of all, we must salute our legal fraternity. It is because of them only that mediation has reached to a platform where India is going to witness a separate legislation. So it was their participation, acceptance, which made it possible, which moved government to have a mediation legislation. So at every point of time, where the contribution of lawyers cannot be ignored, and the draft bill certainly should take care of the insecurity, if any, we have with the members of the bar vis-a-vis the mediation fee or any other concern. Certainly, that is an area which needs correction and thinking. And you've rightly pointed out, sir, because there many people were thinking that this mediation legislation may be a hurdle. It says pre-mediation, pre-litigation mediation may infringe on parties' autonomy, self-determination. But you rightly use the word that what it requires, a limited requirement is that a substantive meeting with the mediator, wherein they can come to, he can apprise the parties about the benefits of mediation and process. So that is the limited requirement which a draft bill as of now is requiring. And there are fragile areas which needs correction. That is like composition of council, where there has to be representation, less representation of a government representative. We should have mediators in that, and list of exclusion is too vast because copyright areas and maybe the minor benefit, we can attempt mediation in such cases also. And domestic mediation clubbed with international mediation is something vis-a-vis Singapore Convention is a gray area which needs more correction and incorporation. And uh, your other concerns are, yes, we can think of pre-mediation in stages, not necessarily in one go, but we can have in different stages where we can think of commercial, consumer, or maybe property dispute, which may help us. But yes, it is really an important moment and a fantastic opportunity for us to witness and to contribute and give representation on this bill. So thank you so much for your views and concern. So I now take the opportunity to invite our next speaker of the day, Dr. Venkat Iyer. Sir, once again, thank you for joining us for today's web event on this topic, putting mediation on a statutory footing, the opportunity and challenges. Before I invite Dr. Venkat, I would like to briefly introduce Dr. Venkat, who is again an inspiration for each one of us, because when we just joined before the program, I was interacting with him and I said, "So there's so much to learn from you. So please be with us forever," because such people, we don't wish like sending them out of India. So please, if there are possibilities, you can please come back to India, be part of our legal fraternity. He's been in Bombay for 20 years as advocate. So, Ms. Dr. Venkat Iyer, a barrister in legal practice since 1981, a trained mediator, a academician attached to School of Law at Ulster University, teaching media law, constitutional law, business law, a lecturer in number of foreign universities in countries like Japan, Australia, China, USA, Malaysia, India, and Taiwan. He has been invited by the royal government of Bhutan to advise on and draft media laws. World Bank has appointed him as consultant to design a program on continuing legal education for the Kenyan bar. He was also invited by the government of Vanuatu to review its Broadcasting Act. He was also consulted by Burmese government on a wide range of media law related matters. Dr. Iyer runs training courses on media law and media ethics for the newspapers, media organizations around the world. He is also engaged in designing and delivering capacity building programs for judges and magistrates in various jurisdictions and frequently runs judicial training programs. Dr. Iyer is the author of number books and articles and editor of journals. So I take this opportunity to now invite Dr. Iyer and would like to know from him, can he think of time where we can say that mediation can replace litigation? So your views, please. We welcome you. Thank you so much. Please, sir. Over to you.
Thank you very much. Can I start by thanking the organizers, Nivaran, and also a particular measure of gratitude to Santan, who has always been indefatigable in his organizational efforts. Can I also record my appreciation of the two colleagues who agreed to do the topping and tailing for the event, Push, yourself, and SS Ray. No less importantly, can I say how pleased I am to be able to get together with my old friend Sriram Panchu again. As you will gather shortly, I come to the discussion with a huge amount of skepticism about the mediation bill. Not because, I hasten to add, I am anti-mediation, quite the contrary, but because I think the bill presents many difficulties, which I shall outline presently. Before I talk about the bill, I want to stress, with all the emphasis at my command, that I'm an extremely staunch supporter of mediation, especially in societies like India. I have to confess that I came late into that position, but like all converts, I now believe in the concept with almost an unshakable zeal. So please don't misunderstand my position simply on the strength of the remarks that I'm about to make. I would ask you to treat those remarks as those of a true friend who considers his duty to hold a mirror rather than as an antagonist. I am in particular difficulty in that, whatever I might say might be seen as criticism of the excellent work that my friend Sriram has done, particularly in relation to a lot of mediation efforts in India, including, I understand, a lot of work on this bill. So again, I want to apologize in advance if I cause any offense. Now, I need hardly tell you that there are at least four fundamental principles of mediation which most of us hold sacred. It is my case that the bill has the potential to strike at the root of all those principles. So, what are those principles? In very simple terms, they are, first of all, the voluntariness of the process. Secondly, impartiality, and you could add to that detachment or neutrality of the mediator. Thirdly, confidentiality of the process. And fourthly, party autonomy and control. What then are my criticisms. I shall divide them into three broad categories and deal with each in turn, almost in bullet point form for lack of time. Perhaps we can expand on these in the Q&A that I understand is going to follow. Now, in terms of what I would call overarching and deep-rooted defects, I would say, first of all, that the bill has a tendency to needlessly formalize or bureaucratize mediation. It's a point which actually I was pleased to hear Sriram make at the start of his presentation. Although, of course, he said many things which more or less set that point that he made. Now, why can't mediation continue to be conducted as it presently is, with the results, if acceptable to all parties and in conformity with policy considerations, being recognized by the courts? Secondly, I believe that the bill is a move towards unacceptable state intervention. For example, the grant of unreasonable powers to the Mediation Council, some very vaguely defined, also questionable and inadequately circumscribed powers of the central government to interfere through directions. There is a dangerous conferment of rulemaking powers on the Mediation Council. For example, how to run mediation, and so on and so forth. I am, as I said earlier, speaking in bullet point form, so I'm not actually elaborating on these, just to sort of give you an overview of what my views are. Thirdly, I think that the bill strikes at the root of some basic principles underlying mediation, as I hinted at the start of this talk. For example, voluntariness, and this, it does this by making mediation mandatory, which is only likely to cause huge friction and discontent, and which will lead, I believe, to all manner of evasions, sleights of hand, and cosmetic exercises. One other criticism I have is that there is overprescription in many areas. For example, qualifications for and registration of mediators, which in my view is a recipe for disaster and for endless litigation. Similarly, recognition and registration of mediation service providers and what are they called, mediation institutes. I see a huge potential for corruption and contention here. One other overarching criticism I would make is that there is some incompatibility with other laws, and I'm beholden to Santan for drawing to my attention an article which was published, I believe, just a day or two ago, authored by a person called Aman Hingorani. And this incompatibility is highlighted in that article, and there are some serious consequences that have been also brought out. And in particular, the article refers to the provisions on audio-video recordings, where there apparently is a direct clash between the civil procedure, ADR, and mediation rules and the bill itself. And this goes to the root of confidentiality. One other probably last overarching criticism I would make is that the bill is extremely shoddily drafted. It'll be a bonanza for lawyers, and it will defeat the purposes of the exercise, in my view, even if one is charitable enough to assume that the exercise is well-intentioned. There are inexcusable bloomers like alternate for alternative, affected for affected, avail for avail of, and so on and so forth. Pretty common in a lot of shoddy drafting. But unfortunately, it has the capacity to make India a laughing stock in the rest of the civilized world. There are many irritating repetitions in the bill. There is needless verbosity, and also some idiotic and meaningless rhetoric. For example, there's a clause which talks about making India a robust center for mediation. What does robust mean? And there are many opaque provisions which make little sense. So those, I feel like, my overarching criticisms. And then I want to talk briefly about what I can call some specific big ticket issues. There is, first of all, a needless and arbitrary distinction drawn between mediation conducted in India and outside India. How does it matter in terms of justice dispensation? Again, I think this is quite sort of capable of generating a lot of needless work for lawyers and a lot of nitpicking by lawyers. There is, I would say, furthermore, needless and arbitrary distinction drawn between commercial and other disputes. Now, if it is for procedural court purposes, for example, whether a dispute should go to the commercial courts or not, that can be dealt with by existing procedural law. You don't need a bill like this to do that. I would say also that there is a wholly unsatisfactory categorization of disputes that can be the subject of mediation. And this is a point to which Sriram has referred very eloquently. So in a sense, I'm treading the same ground. For example, the arbitrary exclusion of many disputes which are perfectly capable of being mediated upon. I would think of cases concerning deities, which is of course unique to India, disputes concerning patents, environmental disputes where there's a blanket ban, and also tax disputes. Now, I can understand criminal law, but I cannot see any rationale for any of these disputes, these other disputes to be completely excluded. I would also consider it entirely unjustified and inexplicable, the exclusion of enforcement of some mediation settlements where the government is a party. Now, it's possible that I've actually not understood this provision clearly, so I'm open to correction there. I see as well that there are some unfair and irrational limitation periods for challenges to mediated settlement agreements. 4 months, including 1 month at the court's discretion. And this is to be reckoned from the date of receipt by the challenging party of the agreement, not from the date of discovery, for example, of fraud or corruption, which should be understandable. What else? I think there is a bizarre, probably accidental or thoughtless conferment through implication or silence of powers of a court on a mediator by putting him on par with a lok adalat in court-ordered mediations. And as Mr. Hingorani pointed out in his article, because the bill does not remove such a presumption existing under the, I think it's the Legal Services Authority Act of '87, then that defect continues to be quite a serious one. And then my third category would be what would be a sort of other issues, miscellaneous matters. First of all, how does it matter whether mediation is conducted online or in person? What is the need to make special provision for online mediation? When it comes to evidential and other matters, then there is clearly provision made in the procedural laws to deal with any challenges that may arise. Similarly, why make special provision for what the bill calls community mediation, a term which is not properly defined, incidentally? It has the potential to open the floodgates for disputes and avoidable contention. As it happens, India has had a long and, I would say, by and large, successful record of mediation within communities without the dead hand of the bureaucracy intervening. Now, even assuming that there is any justification for a body, I'm talking here about the Mediation Council, why should it be packed with government bureaucrats? Experts, which I think is a potential source of cronyism. At another level, there's an absurd provision in relation to community mediation for the appointment of state awardees to mediation panels. Awardees in what? Freedom fighting? Swimming? Kabaddi? Archery? It just doesn't make sense. I would say as well that by providing for an electronic depository for mediated settlement agreements, as the bill does, is not the fundamental principle of confidentiality violated? And no justifications offered for the depository and no indications of how access to it will be controlled. These are just a few of the issues which stood out for me. And I'm sure there are many others which will be commented upon, not only in this seminar, but elsewhere as well. Now, those wishing for mediation to become an indispensable part of the dispute settlement landscape in India, people like me, will be entirely justified in thinking that no law is better than a badly conceived and shoddily drafted measure of the kind that I believe is represented by the present bill. All well-wishers will fervently hope that enough pressure is brought upon the authorities to jettison this, what I would call a retrograde initiative before it is too late. I've said enough and I shall leave it there, but not before thanking you for all your attention and patience. And I can, of course, expect a fair bit of criticism, which I'm happy to take. Thank you.
Thank you so much, Dr. Venkat Iyer. Please be assured that your views and your remarks are not criticism. That's the beauty of our Indian government, our Indian soil, that is why this bill is floated for everyone's views and remarks. So they welcome criticism, and that is why it is here as draft, not as a mediation act or a legislation. So it's a democratic process, and we salute our government of India for doing this act of pre-legislative consultation. Yes, you've rightly pointed out, and you're in consensus with Mr. Sriram Panchu on two basic concepts, which is list of exclusion, which is too vast, and then the intervention of state authorities in the functioning of this mediation council, which is supposed to be formed after we have this act. And there are other areas wherein you feel there may be instances of discontent, corruptions, and maybe it gives lot to the advocates because of the words errors in drafting. But certainly, sir, the representation which will travel from all over India during this month to the government will definitely give India the best mediation legislation, which will be followed and copied by other countries in times to come. We can assure you from here, Indian soil. So thank you, Dr. Venkat Iyer. Before I invite my friend, Dr. S.S. Ray, Mr. S.S. Ray, to give the closing remarks, we would love to have a question answer from our participants, which I initially forgot to say in the opening address. So if any one of you have any questions which you want to put it across to our speakers, please put them in the chat box, and me and my friends, Mr. Ray, would be taking them individually to our speakers. So over to our participants. I think, Mr. Ray, we have one in chat box by Mr. Thankanchan. He says there may be a provision in CRPC to mediate the offences arising out of civil, family, and personal issues. Mr. Panchu, can I take this to you that Mr. Thankanchan has floated his view that there may be instances it's gone up. Sesh, can you just help me pick that up because I'm unable to retrieve that chat box? Yes, there may be a provision in the CRPC to mediate the offences arising out of civil, family, and personal issues. I think what he says is civil procedure code, not criminal procedure code, civil, family, and personal issues. So we are open to that. And we've said in this webinar and even that why we are restricting it to just civil matters. Why can't we take it to the criminal spectrum offences also? So would you like to add on to anything to what Mr. Thankanchan has floated?
I'm not quite sure what the question relates to. Does it relate to the civil procedure code?
Sir, I think what he means to say is that the offences, maybe even if it is criminal issues related to family and personal matters, vis-a-vis the relationship, if it takes to the area which is considered as criminal offense, why can't that be put into the mediation, and why there is a list of exclusion, as you also said, the fraud and coercion, everything?
No, I think he's right. I mean, there are disagreements, there are disputes, and the source for them may not be the criminal acts. It may be more civil in nature. But when cases are filed, because you can get the other person arrested, if you have a criminal charge. Um, so there is no reason why those kind of cases cannot be mediated. Of course, you cannot mediate cases of serious body harm, murder, assault, etc. But a whole lot of other cases falling in that category, we do mediate at the end. But at the end of if it is a non-compoundable offence, and you must bring the court in. You must bring the court or amend Section 320 so that the court can compound the offences.
Yes. Over to you, Ray, Sesh, to pick up the other comment or
Dr.
maybe
Iyer,
question
thank
from
you
the
so
chat.
much. Yeah, so my question would be to Dr. Iyer, who has really given us a very critical, in-depth analysis of this legislation. And he has not minced his words in how he feels. And he has mm, uh, substantiated that, along with the fact that he says that this is a shoddy drafting and it's a retrograde initiative. But my question to you is that do you think that any legislation at all is good for the field, or would it not be any? I mean, suppose this legislation was to be replaced with another piece of legislation. Would you be open to the idea of a legislation in the field of mediation as per se? Or would you say that mediation as it exists today, being an open, wide field without any constraints, is the way forward? What would your view be on this?
Well, I believe that the whole purpose of mediation is to have a system. In fact, it's a point which Sriram very pointedly made at the start of his presentation, is that it has to be informal, dynamic, and something that um flows effortlessly, not to be confined to a bureaucratic framework. And I cannot see why, therefore, there is any need for standalone legislation of this kind. Now, having said that, I am not unaware of the need for statutory underpinnings for certain aspects of mediation. The most obvious, of course, is enforcement of mediation settlements. It'll be impossible for there to be any dispensation of justice without proper provision being made to enforce mediation settlements. But the point I would make is that you need to use existing law, essentially procedural law. Now, it could be rules of the court, it could be civil procedure rules, or in the case of India, the Civil Procedure Code, and laws like that. I cannot see why you bureaucratize the entire field of mediation the way that this bill has sought to do. So I do actually have a fundamental objection to there being legislation in this particular area. And I'll simply draw your attention to what has happened with arbitration. Now, I'm not saying that arbitration does not need legislation. There's a greater case to be made for legislation in relation to arbitration than there is in relation to mediation. But look at how rigid arbitration has become in India. And it is extremely difficult actually to resist the conclusion that all that has happened is arbitration has become a bonanza for lawyers. In other words, there is an extra layer added to the already unsatisfactory scheme of things in relation to dispute resolution. So that's where I come from. And I am able to say this with the advantage of distance. What I would argue respectfully is that a lot of people who fall for the idea of the need for standalone legislation for mediation is that they are missing the wood for the trees. If you look at it more in the round, I think a case can be made for there not being any such legislation.
Thank you, Dr. Iyer. Push, please, there a question?
Yes, we have one from Shireen. That's for Mr. Panchu, sir. Sir, can I put that across to you? Yes. So Shireen is asking, in a family dispute where one party is in India and the other is abroad, it will not be international mediation as it is limited to commercial disputes? Question mark. So can notice be sent by the mediator to the party abroad when she is approached by a party in India for pre-litigation mediation? Further, she adds, what would be the effect where person abroad is an Indian and also where person abroad is of different nationality? So there are three questions in this.
Yeah. Let me try and answer that in a simple fashion. I think there is no problem in asking the person abroad whether they are willing, they're amenable to try mediation. Yes. The problem would only come, if you're trying through the legal process to enforce that person's attendance at a mediation session. That is a difficult matter, but inviting a person to join in mediation, and especially now with the possibility of online, is certainly open. Where you will ultimately, enforce the agreement is based on what happens in the mediation, what the facts are, and what agreement comes about. But to initiate the process, I think no problem at all.
Thank you, sir. Thank you. Seish, we have one from Mr. Mendes. If you can take that.
Push, can you take that question? I have a question for actually Mr. Panchu, because when he opened, he referred to the uncluttered field in mediation. And one of the key drivers that he mentioned was the requirement to have at least one mediation to begin with before any kind of litigation starts in full earnest. Now, in this respect, my question would essentially be that when a party is totally geared for a litigation, and from whatever experience we have had of mediation so far, mediation is always done, there is a stage for mediation, like plucking a fruit when it is ripe. There is a certain amount of litigation fatigue that sets in, that kind of goads the parties, motivates the parties to go in for a mediated settlement. But to push the parties to first try a mediation, would it be counterproductive? And how would you react to this particular clause? The fact being that you have said this is one of the key drivers.
These things can vary. On the one hand, you can say that a fatigue will set in after some litigation, and that will make the party more amenable to mediation. Equally, on the other hand, what can happen is by the time they start trading charges and accusations against each other, they will be far, far away from mediation. So it's difficult really to kind of to prescribe on that basis. I think what this bill does is to give you a halting threshold and to say, look, before you really start the litigating process, because mind you, once you get on to that process, it's like riding that tiger. It's not easy to get off. So what the bill gives you, what the act gives you, is that threshold pause. The pause of sitting with an independent, with a neutral, and to have a discussion on things that lawyers really never have with their parties. What is your long-term interest? What do you really want? What are your alternatives to settlement? A bit of legal realism. These conversations are never had between lawyers and parties. These are the conversations that you have with a mediator. And even if it is 10%, 20%, 30%, of people who say, well, let me reconsider a bit, or let us take this, let us do something which will, for the time being, make both of us, comfortable, and we can sort this out. Because there are a large number of cases, and I'm talking from experience, where the judge says in court, try mediation, and the parties say, no, we don't want it. And the judge says, no, go down, try it. Have 2 sessions and come back. And when they come to the mediation session, they are ready to go back. But at the end of the first or second session, you find in many cases that people are really interested in talking about settlement. What we have to do is to ensure that because you're asked to go to mediation for 1 session, you don't lose the risk, you don't lose out on any urgent interim relief. And this bill provides that. If you want interim relief, don't go to the mediation. Go to court, get your interim relief sorted out, and then go to mediation. So nobody's being hampered on that score. So I think there's chance for another kind of thinking. Does benefit people.
Thank you.
Yeah. Sriram sir, can I have one question to you? The draft bill speaks about community mediation. If it at all remains in the main mediation legislation when it is introduced, it does not speak about the panel of mediator which has advocates. So do you think the advocates are not required in community mediations? The qualifications which are prescribed for panel of mediator in community mediation under section 47 subsection 3, it does not speak about advocates. So can we think of community mediation without advocates to see whether the agreement is executable, enforceable in law? I think it is indispensable to have advocates.
Yeah, I mean, I didn't, 47, is it?
Yes, sir. Section, it is 47(3), Community Mediation Part 2.
Oh, this was that Venkat made about who are these awardees.
Yeah, so they've left it to people who are of some standing and integrity, but ultimately when it comes down to writing the terms of agreement, mediation settlement agreement, so one has to see whether that's enforceable by law.
Well, in fact, I don't know this thing. I don't even know whether this talks about mediators.
Yeah, sir, it says panel of mediators to be formed by the district magistrate, subdivisional magistrate, SDM. He has to constitute a panel of mediator for facilitating the binding settlement of such disputes. And then there are qualifications. So it does not talk about advocates. This is something.
Mediators from any good service provider.
Yes.
Yeah,
Maybe maybe does not consider lawyers to be of some standing or integrity, so they have not included advocates.
No,
But certainly I feel so that we should have advocates.
I think you're right. This deserves to be looked.
Yes, if at all community mediation remains in the act, so it should be.
Yeah.
Yes. So thank you so much. Sesh, we have views from Mr. Mendes that he is also of the view why there is a blanket ban on criminal disputes and cases under this act. Then we have one from Miss Mandali Sarathi. She says, why limitation at all for a mediation? So these are the views which are mooted in chat box. Can you just see if we are missing anything else? There is one by Miss Lakshmi Shibu. Will the mediation bill help in reducing the pending cases in various courts of our country? I put it to both speakers of our day, Dr. Venkat Iyer or Mr. Panchu, to take this.
Sriram, do you want to go first, or can I, in one sentence, answer that question?
Please, sir.
I think Venkat, you should go because you have this art of demolition through one sentence or word. So you may go.
No. Okay.
Bullet points, sir. Bullet points, as you rightly said.
The very short answer is not if this bill is to go ahead.
Okay, fine. Thank you so much, sir. Anything else? I hope we are not missing in,
Actually, there are so
anything
many
from the.
questions that are being raised by so many of our attendees. One of them, and primarily why we would like to pose this question to Mr. Panchu, is that will the act not actually tend to limit the field of mediation, which was otherwise wide open? Why do we need this particular legislation? What was the felt need for it? Can we, because I think one of the criticisms drawn from Dr. Iyer is very well taken, is unnecessary bureaucratization of and formalization of a field which was otherwise open. And it was mediation was something where you would want to come to a settlement thinking on your feet. The mediator would only be in charge of the process, not the outcome. Today, there are so many ifs and buts, which actually gives the litigating lawyer a chance in nitpicking on by virtue of the legislation itself. So, sir, really, we want to know what, because since you have been one of the architects and fountainheads of this legislation, how would you want to respond to this?
Well, let me firstly tell you that the draft of which I was an architect has undergone lots of changes before it's come here. So I'm not going to be pilloried for something so easily, number one. Number two, look, you started something in the courts in 2005, okay? Through that court process, you made mediation known, recognized, appreciated, but used very much only in the court process. So you have a choice. You say, well, we won't do anything, but let us just have mediation in the court annex system and hope that, it trickles down to the outside the court arena. People know about it, they talk about it, it's a trickle down effect. That's one way of looking at it. The other way is to say, all right, we did these things for the court annex system. Now, what do we need to do for disputes out of the court annex system, disputes which have not gone to court? What do we need to do? Shall we do something in that field? I look at it as the 80-20. You've taken care of 20 through the court system. So outside that system, are we going to take proactive steps? Or do we just sit back and say, by osmosis or reflux of time or trickle down effect, mediation will become popular outside the court system? There is a choice, and this act makes a choice. I mean, I completely agree with a lot of things, criticisms, I think, about the bureaucratic part of it, some of the drafting. Um, but I think there's a choice that one had to make. Are we going to take proactive steps to spread this so that as many cases as possible go to mediation? I mean, that's the crux. As many cases as possible go to mediation, um, and try and create a base of professional mediators, and really to make this, a profession. Not something done by people, after 4:30, after court working hours, and sitting down and trying to resolve cases. Are we looking at making mediation a professional activity, full-fledged? Are we giving people in dispute the opportunity to go to a mediator at the first stage? So I think that's the approach in this act. And I would suggest that we meet in 1 year's time and see where we are. So, Mr. Santana Krishnan, can you please mark that in your calendar for the next year? We come together and we do a review of where we are. Santan's not saying anything.
Sesh, can we take one more question before I invite you for the closing remarks? If I can put it across to Dr. Venkat Iyer, and it is from Uma Ramanathan, ma'am, our very senior mediator and mediation trainer of our country. She says, are we focusing more on compliance and enforcement to target success rather than real autonomy and informed consent, which is the core of the mediation? If so, are we not striking at the core?
Striking at the core of what?
Mediation,
Right.
maybe what you said, the principal elements of mediation. Maybe she's taking us to that.
All right. I would go back to the essential point I was trying to make, and it's possible actually that I've not been successful in making that point, for which the blame lies entirely with me. It is this, that notwithstanding everything that Sriram has said, I would actually throw the whole argument back at Sriram and say, look, people like him have been doing an excellent job without the crutches of any such law. Why upset an apple cart that is not in any way disturbing anybody? It's actually going reasonably well. Now, there are many reasons why mediation is not popular in India. And I don't think those reasons can be cured through legislation of this kind. If I have to be, again, as brutal as I've been, I would say that in India today, everyone except the honest litigant has a stake in the very decrepit system that exists for the dispensation of justice. And I say this with a full sense of responsibility. It includes lawyers, it includes judges, it includes touts, it includes so many people. So if there's a serious attempt at resolving disputes, then I think there are better ways of going about it than drafting something as retrograde as a bill like this. Mediation is something which needs to be encouraged at all levels and very robustly. And there are ways of doing it, because if you start institutionalizing in this way, bureaucratizing it in this way, then all that will happen is you will have a further layer of litigation. Believe me, and I think Sriram's point is a very well made one. If we were to return to this theme, not just a year from now, because I suspect it'll take more than a year for the law to be passed and operationalized, then we'll find that the scene is more murky than it is at the moment. In other words, you will have all kinds of cases being filed in court, all kinds of attempts being made to bypass this requirement of mandatory mediation, etc., etc. And who is going to benefit? Definitely not the honest litigant. That is the point I've been trying to make. And as I said, it's possible that my powers of persuasion have not been adequate to make that point as effectively as I should have done.
Thank you, Dr. Venkat Iyer. And with your words, I will hand over to Mr. S.S. Ray, and with the hope that soon we will have an enactment which has no loopholes, no lacunas, and soon India turns out to be a mediation tourism hub for everyone, where they are well protected by a proper law, which is rational and acceptable to everyone with the vision and object it is laid before us. So over to you, Sesh.
Thank you, Pushp. Thank you very much, Mr. Sriram Panchu and Dr. Iyer. We were extremely benefited by your line of thinking, and whether this act actually musters legislation or whether it remains in the draft stage is yet to be seen. But one thing is certain, it has clicked off our thinking on these lines, and that is the positive takeaway over here. Mr. Sriram Panchu had flagged off 4 essential concerns. One is the key driver, he said, was the pre-institution litigation. Another one was the composition of the council. The third was the list of exclusions, which were too widely cast. And the fourth was the Singapore mediation. While I do tend to agree with what Dr. Iyer has said on many of the aspects with respect to bureaucratization of the field in mediation and an unacceptable state intervention and the 4 main principles which seem to be hit, that is voluntariness, impartiality, confidentiality, and party autonomy. In this respect, of course, mediation as a field, as has started in 2005, has come a very, very long way. Really, in 16 years, it has picked up a lot of momentum in the past 5-6 years, and especially in legislation we see, because mediation otherwise has now taken a legislative route in various legislation. For example, under Section 442 of the Companies Act in India, the Commercial Courts Act 2015 has Section 12A, again speaks of mediation. Then there's the Real Estate Regulation Development Act. Of course, it's very kind of hidden over there under Section 32, subclause G, and the Consumer Protection Act, which gives you a full chapter, Chapter 5, from Section 74 to 81. So therefore, mediation is actually also being encouraged legislatively. But the question still remains open whether or not we need a mediation, a complete legislation for the field of mediation, which is a very, very important question. And this is a draft that really needs to be debated and dealt with, because it is one of the 3, now it is taking up one of the 3 prime routes of dispute resolution, apart from established routes of litigation and arbitration. But the idea of having a mediation where you'll have an international mediation and the mediator is going to send notices, I think this is just nitpicking on a field which could have been left so beautiful, so open, and without any technicality, so to say, if I may use the term, which lawyers find so delicious. And certainly mediation will be very lawyer friendly, if I may say that, the mediation bill. So on that note, I thank all of you. I thank the participants, and this thank you is from Nivaran, the Supreme Court mediators. And we also thank, of course, our technical team, where Mr. Rahul is heading it, who makes this entire thing happen seamlessly. And for your time, and all the participants who have participated very actively by writing on the chat box. I'm sorry, there were some people who did raise their hands, but we could not take their questions because that is really not our format. If you had the questions, you must put it in the chat box. And we would certainly take this discussion forward on some other time. And of course, we will definitely take up the offer from Mr. Panchu that 1 year hence we'll take stock of what has happened from what is today, so that we may know how this bill is going to travel and whether or not this bill will see the light of day. There are a lot of bills that are drafted all the time, and we don't know whether it actually becomes a law. But yes, as a first stepping stone, I think it is very good. Just as we say that what is your contribution to law, even a bad argument is a contribution to law because it sets you on the right path to think. So therefore, thank you, everybody. Thank you, Push. Thank you, Mr. Panchu. Thank you, Dr. Iyer. And thanks to all the participants over here.
Thank you, sir. Thank you, Mr. Sriram Panchu, Dr. Venkat Iyer. Thank you so much for joining us today. Thank you. Thank you so much. And thank you, everyone.